So good afternoon and welcome everybody to the Graduate Life and Learning. My name is Mohammad Shifatusami and I'm a Global Liner Graduate Assistant here. Many of you are already acquainted with our activities. For those of you who are new at the CGLL, our mission is to provide a comfortable and safe environment where graduate students and postdoctoral fellows can network and get personal and professional support to enhance their career success. We organize various events every week and on a regular basis to help you get through the challenges of graduate life. You'll find out about these events on our website, and I'm going to put the link to our events calendar in the chat in a minute. So today we are partnering with our international students and scholars office, that is ISSO, to inform you about the green card application process after graduation. Thank you so much to Dylan Kloster, our international student and scholar advisor, for being with us here today and helping us organize and promote this event with all of you. And finally, and most importantly, of course, we are very honored to have attorney Mr. Raju Mahajan with us today as our guest speaker. Mr. Mahajan is an experienced employment-based and investment-based attorney. He has helped a lot of people getting green card all over the US. He himself is a poster boy for the American dream. He received his green card through EB2 NIW back in 2014. So he truly understands the extra barriers that many immigrants face when they need legal help. Although he is an expert in the employment-based national interest waiver, that is EB2 NIW application, he's also sound in EB1, EB2, EB5, E2, asylum, and family-based green card applications. Now, in today's session, Mr. Mahajan is going to highlight the green card application processes that are available for you if you're going to apply after your graduation. We have a similar event coming up on next Tuesday, that is February 8th, with Mr. Mahajan, where he will highlight the options that are available for you if you're going to apply before you graduate. You can ask your questions directly to him at the end of the session, or put it in the chat during the presentation, and I'll ask him for you at the end of it. So ladies and gentlemen, without further ado, let's welcome Mr. Mahajan.
Thank you so much, Mr. Sami. Thank you so much, Laura and everybody. And especially thanks to those who are watching our show, today's webinar. So as a housekeeping, let me tell you a few things before I discuss on PERM. So this is not a legal advice. This is just a webinar on immigration. It's the only purpose of this webinar is information gathering and to better understand the process. For legal advice, I must talk in person with the person individually and discuss about the individual facts and documents, not like a general discussion. So today's purpose is just for information, and this is not a legal advice, just to make sure. Another thing, I have a little cough. So in the middle of the discussion, I may cough a little bit. I really apologize for that. I'm taking medication, but it's taking a little longer than I expected. I'm sorry for that. Also, when I will speak about different things, you can either ask me a question in the middle of the discussion or at the end of the discussion. I'm okay with either. Whatever the organizers did prefer, I'm okay with either way. So let's start. As Mr. Sami said, there are two major ways to get green card. One, there's two major ways to apply for a green card. One, you can apply with a job. Also, you can apply without a job. So if you want to apply for green card with a job, you must wait and graduate first. After your graduation, you'll get a job and your employer will file for application. You cannot do it by yourself. So today we will focus on that application. It's called regular EB2 and PERM is just the first step of that application. But many people, they identify the process at PERM process. So that's why I put PERM, but the official name is EB2, employment-based application, and it's called regular EB2 because NIW EB2 is something that you can do it yourself. So let's start about the PERM process and what are the requirements, what to do, kind of things. So let's go to the next step. Yeah, so Regular EB2, like the EB2 by itself, has three different categories. One is advanced degree, one is exceptional ability, and number three is national interest waiver. So no matter you, so that the first two step, advanced degree and exceptional ability, with these two category, you can go for PERM process, like employment based application. The third one is NIW. You can go to NIW from that two steps too, but in general, those two steps are for PERM process. So usually when people graduate with a degree, those who have STEM subjects, first they go for OPT. OPT is for everybody. Everybody gets 1 year of OPT. After 1 year of OPT, you apply for 2 years extension if you have STEM OPT. Recently, Department of Homeland Security, they expanded the scope of STEM subjects. And I'm hearing from many people that hopefully within a very short time, all subjects will be considered for 3 years OPT. So everybody will get 3 years of OPT, which is really game changer for international students. I'm really waiting for that. But until we get that, right now, all students get 1 year of OPT, and some students, they get 2 years extension. So you can get a job within this OPT time. Once you get a job, your company can directly apply for green card. Even though most of the company, they don't directly apply, they will ask you to go through H-1B. So the reason they do that is they want to keep you for a long time. But officially, they can apply for green card from the very beginning. You don't need to go through H-1B, but most of the company, they will ask you to go through H-1B. But they're your employer, they're your boss. Whatever they say, you have to follow that. I'm not discussing about H-1B process in our webinar today, because that's a different discussion, and we may have like a different webinar on H-1B. Today, we will focus on green card application based on your employment. So let's say you are in OPT, you applied for H-1B, and you have been picked, and you have been working for that company for a pretty long time. And now your company decided that, okay, we will apply for green card for you. Then this PERM process starts. And these are the basic 3 stages of getting an employment-based green card, EB2 and EB3 in US. First one is PERM/labor certification. Second one is I-140 immigration petition. Number 3 is I-485 application for adjustment of status. So a lot of people, they're confused about EB2 and EB3. What is the difference between EB2 and EB3? So process-wise, this is like 98% same thing, EB2 and EB3. The only difference is EB2 requires advanced degree. You must have a master's degree or higher degree. So either master's, PhD, postdoc kind of degree for EB2. EB3 is either undergrad degree or no degree at all. So if you have an undergrad degree and you got a job and your company is trying to apply for green card, PERM application, it is EB3. Also, a lot of jobs, they don't require any degree. Let's say you work for a restaurant or gas station or something else. I know, you're a student, university student, you may not go for that kind of job, but a lot of people, they go for that kind of jobs. So those applications are under EB3. So undergrad or below EB3, masters or upper EB2. Other than that, everything is pretty much same. That's why this process that we'll discuss today is same process for both EB2 and EB3. So the first step is PERM. This is the most important step for employment-based green card application. Second and third steps is kind of like pretty straight. Those are just forms. And one another thing is, people from some countries, they can apply for a step 2 and a step 3 at the same time, concurrently. Like people from Bangladesh, people from Nepal, Sri Lanka, like most of the countries, they can apply for stage 2 and stage 3 concurrently. But people from some countries like India, China, Mexico, Philippines, I think Colombia and some other countries, they cannot apply for I-140 and I-485 concurrently. Immediately after PERM, they can apply for I-140. Once your I-140 is approved, you have to wait a long time in some cases it's almost 10 years to be able to apply for I-485. So it depends on available visa and depends on the country you are born. It's not the country you are from. Let's say, let me give you an example. Let's say one person, he was born in India and later he become Canadian citizen or Australian citizen. Now he is trying to be US citizen. His his country of chargeability, they call it chargeability. It depends on the place he was born. So even though he is a Canadian citizen or Australian citizen, doesn't matter. He was born in India, so his determination would be dependent on his place of birth. That's why a lot of people, they say bad things about this process, this whole quota system, and there's a lot of movement. But until today, the quota system is still valid. That's why we have to discuss this. If this quota system is waived, then it would be open for all. But until today, the quota system is there. So it depends on your country of birth. So people from other countries, they can directly apply for stage 2 and stage 3 together. So that saves their time. I will discuss about I-140 and I-485 a little later. So first, I'm focusing on PERM. So what is PERM? PERM stands for Program for Electronic Review Management. So it just is your application is electronically submitted and they review it electronically. That's it. That's like PERM. And PERM process is 100% with Department of Labor. It is not connected to USCIS or Department of Homeland Security. So, all the immigration things are overseen by Department of Homeland Security. In some time, it is connected with Department of State. If it is involved with any kind of visa, embassy kind of thing, it's Department of State, but mostly Department of Homeland Security. But PERM process is overseen by Department of Labor. So a lot of people, they don't understand the difference. So, and this, frankly speaking, this is not a major difference. Like from a client perspective, it's not a big deal. But from our point of view, sometimes PERM process is a little different from USCIS process because it's a totally different department. So when we process this PERM application, we need to follow what are the latest rules and regulations of Department of Labor, not USCIS. And most of the time, immigrants, they follow different rules and regulation changes of USCIS. Those are not applicable here. PERM process is 100% Department of Labor requirements. So let's go to the next step. Okay, so there are 4 steps within PERM. So initially I said employment-based immigration has 3 steps: PERM, I-140 and I-485. And now I'm discussing 4 steps within PERM. So the very first step is prevailing wage determination. Some people call it PWD, the same thing. Prevailing wage request or prevailing wage determination. So what it means is when you apply for any kind of green card application through employment-based or even H-1B application, you must go through prevailing wage determination. It means the location of the business, the type of the business, the type of your position, and the requirements. Let's say they are asking for master's degree with some experience or master's degree with no experience. All this information will determine what is the minimum wage the company must pay you. It's not in a federal minimum wage. Like, in North Carolina, I think the minimum wage is federal minimum wage, which is like $7 something. It's not that. Let's say there is a IT company in downtown Charlotte, and their minimum requirement is you must have a bachelor degree plus 2 years of experience. So based on the location, downtown Charlotte, based on the requirement of bachelor degree plus 2 years of experience and some other factors, let's say Department of Labor determines that, the minimum wage should be $15 per hour, which is very different from federal minimum wage. So, and it depends on the location, it depends on the industry, it depends on the experience and all the other information. And the reason Department of Labor wants to do that is to protect local workers, because if there is no prevailing wage determination, then companies can hire international students with a very minimum wage, and they can deprive local people. That's just to protect local people. They also it's good for international students too, because if there is a minimum prevailing wage, then the company cannot exploit your need for a green card. So it's good for both local people and international students. So I wrote here prevailing wage request is 2 weeks processing time. Not always. It depends on many factors because of the COVID and some other reason. Recently, sometimes it takes like 6 months. So, and also there are many sources of prevailing wage determination. Sometimes we apply to the Department of Labor and we get it from there. Sometimes there are some private companies and some private sources we can get the prevailing wage. So those are the very like legal kind of things you do not need to know, because most of the time like lawyers will take care of this, and it depends on the time, it depends on the location. So but as I said, the time for prevailing wage determination depends on many factors, including the source where we are getting the prevailing wage. If we apply directly to Department of Labor, sometimes it takes longer. So sometimes what we do, we contact different survey company, private survey company, and they sell data to us, and we get prevailing wage from them. In that case, there are some additional requirements to fulfill, but usually those are a little expensive, but they save some time. So we kind of like, we ask the employee, hey, if we go to a private company for prevailing wage determination, it may save some time, but it may be a little costly. What do you think? Do you want to go through that? If they say, yeah, let's do that, then we go to that path. If they say, no, it's okay, we have time, we don't want to spend a lot of money, then I say, yeah, it's okay, we'll go to the Department of Labor. So those are like case by case basis decisions. Once we get the prevailing wage, let's say, let's say the prevailing wage is $15.30 per hour in that particular job. The next step is advertisement. For advertisements, there are 3 requirements. One, we must publish a advertisement for 30 days in the state's workforce agency. So in our example, downtown Charlotte, the state is North Carolina. So every state has a workforce agency, and every workforce agency has their own online notice board. So we must advertise in that online notice board for at least 30 days. To be on the safe side, we usually do for like 33 days or 35 days, just to be on the safe side. We do that. Second is, within that 30 days, we must publish in 2 consecutive Sundays newspaper edition. So let's say in downtown Charlotte, there's a newspaper called, Charlotte Gazette or something. Within that 30-day period, we pick 2 consecutive Sundays and we publish that advertisement like a printed copy in Charlotte Gazette's newspaper. Usually it doesn't, by the way, the workforce agency advertisement is free. We don't have to pay anything. The newspaper advertisement is not free, but it's not very expensive either. It's like for 2 Sundays, it will take like $400, $500 kind of. Excuse me. The third requirement for advertisement is the actual workplace. So the office, if the office is in downtown Charlotte, excuse me, they must post like a paper kind of posting, like help wanted in front of their common space. If they have a notice board or in front of their bathroom somewhere, they must publish that we need people in this location, and that at least the employee of the company will know that they are trying to hire somebody. So 3 requirements: 1, state workforce agency; number 2, local newspaper for 2 consecutive Sundays; and number 3, the actual worksite advertisement. Once this advertisement is over, if there is more applicant other than our actual applicant, then the company must take interview, and if they find a local people like a US citizen or a permanent resident who is capable enough to do that job and they meet all the requirements of the advertisement, then the company must hire that person. They cannot hire a non-immigrant international student if they have a local person available. So some green card application stops there because they find a local person. In most cases, they do not find a local person, because if they find a local person, they would not go through this process anyway. So if there's like a more applicant and they are not qualified, then we can only proceed to the next step, recruitment. Let's say there's an advertisement, there are some people who applied and they're not qualified, so they only recruited the person we are trying to help, with this process. And the recruitment process is pretty straight. It's just an employment contract signed by the employee and the employer. And if the person already has a work permit, they can start working immediately. If the person do not have a work permit, then they must wait for I-485. Until then, they cannot start working. But employment contract would be valid. Like they can sign the contract, but they cannot start working. So when the recruitment is over, then they must wait 1 month. It's called quiet period. When recruitment is over and the quiet period is over, then we apply for labor certification to Department of Labor. This one is mandatory to Department of Labor. There is no private place to submit this application. For prevailing wage, there are private sources, but for labor certification application, we must submit to Department of Labor. And this, in this timeline, I said application takes 24 weeks, like 6 months. This is kind of like a best case scenario, 6 months. Sometimes it takes longer. So once we submit this application, we must wait for at least 6 months. We get labor certification approved. Then we move to the next step, which is I-140. So I-140, we can only apply once we have approved labor certification. And I-140 will not give you any benefit. It's just an application. As I said, it's like an immigration petition for alien worker. However, one important thing I should tell you, this I-140 can be applied with a premium processing. Of course, it requires like extra payment of $2,500, but with premium processing, we can get it like approved within like 3 weeks. So a lot of people, they prefer I-140 with premium processing. Regular fee for I-140 is $700. With premium processing, $2,500. So it would be like $3,200. A lot of people, they say it's okay, $3,200 is not a big deal. I will go for premium processing. A lot of people say, it's okay, let's go slow. I don't want to spend additional money, so I'll just go with $700. By the way, the previous application PERM process does not have any expense. The application for PERM labor certification to Department of Labor is free. The only expense in PERM process is advertising cost, which is like $400, $500. Sometimes it's like $200, depends on the location and newspaper. So that one is free, just the advertisement. I-140, $700 plus premium processing fee if there's any fee. And then the last step is I-485. And this is actual green card application. I-485 is actual green card application. So with I-485, we also apply I-765, employment authorization, I-131, which is travel document, advance parole. Also, if you have a spouse and children, you apply for them in this stage. Before they are in the PERM process, there is no application for spouse or children. In I-140, there is no application for spouse or children. This is the first time you apply for your spouse and children if you have. And I-485 government fee is for adult person above 14 years is $1,225 per person. And if there's any child under the age of 14, it's like $750. So it's like a lot of money for I-485 application. Also, this I-485 application do not have any premium processing. So let's say I-140, you're from, let's say you're from Nepal or Bangladesh or from Sri Lanka or Burkina Faso, the country I said the other day, or let's say you're from Peru or Chile. You're applying I-140 and I-485 together, and you applied I-140 with the premium processing. So it takes only 3 weeks to get approved, but I-485 doesn't have any premium processing. So at the end of the day, you must wait for the entire period of I-485. So sometimes it doesn't save a lot of time. Sometimes it's a little helpful, at least like a peace of mind, like, hey, at least I have I-140 approved. So for peace of mind, a lot of people, they want to go through premium processing, $2,500 additional fee. A lot of people say it's okay, let's go slow. So it depends on your situation and your financial situation. So whenever anybody asks me, hey, should I apply concurrently or one after another, I say, let's talk, let's see your situation, what do you need, and then we decide. Once I-485 is approved, boom, you get the green card for yourself, your spouse, and your children. So this is This is the entire process from PERM process from beginning to end takes usually like a 1.5 year to almost 2 years. So it's a very time consuming process. It's like a long process, and a lot of time company lawyers, they make it a little slower because the purpose of company law, this is a legal thing, and a lot of people hates lawyer for this kind of work. But let me tell you one thing: when I work for a company, my client is not you. My client is the company, and my entire responsibility, my duty of care, my everything is towards the company, not you. So when my company tells me, hey, can you please make the process a little slower because we want to keep the employee as long as possible, the lawyer must listen to the company, and lawyer must make the process slower because that is his job or her job. So a lot of time people tell me, hey, our company lawyers, he's very slow. I don't know why he took like 3 months just to submit the application. And I said, well, probably because your company asked him to go slow. I mean, if the company asks him to go faster and the lawyer does it slow, that's his fault, his mistake, and he should not do that. He should never do that because he must listen to what his or her client is asking. But in most cases, in my experience, companies ask them to go slow. That's why if you are employed in a like a startup company, like a small company who do not have their own lawyers, um, I get a lot of PERM-based clients whose employer is new. They have no idea about green card application, and then they come to me. In that case, we help the company file for PERM and I-140 and I-45, and I tell the person, the applicant, say, hey, you know what? The day you're signing the contract, your company is signing the contract, you are no longer my client. The company's client. So if you want me to do that faster, I can definitely do it. But ask your HR manager or CEO or whoever is taking care of you, ask him to ask me to make it faster because my whole responsibility is toward the company. So this is kind of very internal thing. I'm just telling you in advance, just to that let you understand the situation. So this is the process, and a lot of people, they get green card through this process. Especially now, NIW is very popular, but before NIW was popular, and in 2016, one federal circuit court judge, he actually made this NIW case way easier than before. So before 2016, this PERM process was the #1 way to get green card for international students. Now NIW is the #1. I will discuss about NIW in our next week's webinar. But PERM process is still one of the most popular ones because in most cases, companies pays for attorney fees and a lot of application fees. So if you get a job with a university or big corporation, in most cases you don't have to pay any money. Like the company is, especially PERM and I-140, they will pay, and then they'll say, okay, go ahead, find your attorney for I-485. So it's financially, it's kind of like better, but in terms of time and in terms of the control over the situation, in NIW you have more control over the situation than PERM process, because as I said, attorneys are working for the company, not for you. So this is the overview. If you have any question about any topic within PERM, feel free to ask me. If you ask question about other topics, I would probably say, let's discuss in another day. Yeah, so thank you.
All right, so if anybody has any questions that you want to ask Mr. Mahajan, you can ask him, and I have a few questions in the chat, so I'll ask him later.
Exactly. I prefer you guys ask in the chat, and Mr. Sami, can you please read that for me?
Yes. So the first question is that Willow shared it with us via email. So what we're going to do is that we are going to upload this recording on YouTube and send you the link. The next question is, so if you are getting the OPT, but you must have a job within 3 months of your OPT starting, and they want to start this process, would it make it invalid? Since you technically don't have a job yet until all these steps get approved.
No. Okay, so this one is a little confusing. Thank you for asking this question. So the work authorization we are applying under I-485, you do not need it if you have a OPT, because if you are in OPT, you already have a work authorization. That is the point of OPT. So let's say you graduate in this May of 2022, and immediately after graduation, you apply for OPT. I mean, you apply OPT before graduation, and then immediately after graduation, you get work authorization under OPT. You can start working for the company immediately, and the company can start applying PERM immediately. Company doesn't need to wait for anything. Even company can file for PERM even before they hired you, because in many cases they bring people from foreign country who are not even in America. They're not in OPT or anything. They bring people from a foreign country through this process. So you have an OPT, you will start working for this company immediately, and if the company wants, they can start the process immediately. There is no problem. We again apply for a work authorization under I-485. That one is different from OPT. I mean, it's the same work authorization, you can work, but it's a different application, and we do that because it's free. That's why we do that. But technically, you do not need that work authorization until you have a OPT.
Okay, next.
Did I answer the question?
Okay.
Yeah. If there's any other question about this, please ask me. I'll answer again.
Okay, the next question is, does the employer have to prove that no US citizen meets the minimum requirement for the job?
Yes, and that is the point of those advertisements. So let's say, you know, when they did all that, like 3 advertised requirements, and they've, like, let's say 100 people applied for the job, and they did not find anybody qualified who is a local person. They hired this international student. They must keep the record, of all the interviews and why they did not hire those local people. In general, they don't need to submit that to Department of Labor for labor certification, but let's say 2 months after the application, Department of Labor started an audit. In the audit, they must show that, hey, we, after our advertisement, 100 people applied and we took interview, and these are the local people who showed up in the interview, and their interview was not satisfactory. That's why we did not hire those person. And this person, his interview was very satisfactory. That's why we hired him. So they must keep all the records.
Next question. At what point in process can spouse enter the US? And can the spouse work during the process?
So spouse cannot enter anytime in the PERM process. In the green card application, if the spouse is not in America. So let's say that in a different way. Let's say Mr. X is an international student here. He is in OPT. His wife, Miss Y, she's in their home country. So Miss Y can come to America anytime as a spouse of OPT student, like under F2 visa. But this PERM process will not help you to bring your spouse anytime. So let's say you are in America, you're a spouse in a foreign country, you have done with PERM process, I-140 is done, I-485, if you are in America, if your spouse is in America, you can apply I-485 for her. But let's say you are in America, but your spouse is in foreign country, then you cannot apply I-485 for her. You must apply I-485 for you, and DS-260 is called Immigration Visa Petition for her in the foreign country's US Embassy. So in that case, it would be different path for 2 persons. So the short answer to your question, this entire process will not let you bring your spouse in America under this process. But if you have a valid visa, if you have a valid F1 visa, you can bring your spouse with your F2 visa. If you are in H1B visa, you can bring your spouse with H4 visa. Those visas will help you bring her here, but this PERM process will not allow you to bring your spouse here.
Next question. If I don't have OPT, do I need to wait until USCIS approved the application, or once labor approved the I-40?
Yes, if you do not have a OPT or any other kind of work visa, then you must wait until we apply I-485, and with I-485 we submit I-765, which is like a work authorization. And not just applying, after we apply I-765 under I-485, it takes another 4 or 5 months to get it approved. Only then you can start working. So in terms of time, usually if you do not have a work authorization right now, you have to wait almost more than 1 year to start working under this process.
In STEM OPT, we have 3 years to work, and after that, we need either H-1B or green card. My question would be, when should I request the employer to start processing either H-1B or green card? As soon as my 3 years of OPT start, that soon?
Yes, what I would tell you is as soon as you get a job, like in the very beginning of the job, try to make a good relation with your HR person or CEO, whoever is, or your departmental head, and request them for either H-1B or PERM process. Because it's not that you just request them and they will say, yes, let's do that tomorrow. They will not say that. They may take time. So you should start talking about this as early as possible. Try to do that in the beginning of your job. Also, one information you said is half true, half false, is once your 3-year OPT is over, you have an option to go for either H-1B or green card through this. But no, there's another option. It's called a day one CPT. So let's say your OPT is over 3 years and you have neither H-1B nor green card or nothing, then you can always start day one CPT. It's not very prestigious, but it works, and you get a work permit under this, and you can keep staying in America and working.
What do you do when you get a job offer, but is still waiting for your pending I-485?
So if you get a work offer and you have a work permit, let's say you are in OPT or you are in H-1B, you start working with that company immediately. You do not have to wait for I-485. But let's say you do not have a work authorization. You're neither in OPT nor in H-1B. Then you have to wait until the work authorization is approved under I-485 to start working for that company.
Just to see if I understood well, the work authorization comes at the end of the PERM step, right?
No.
Which means after 7+ months?
No, the work authorization comes not at the end of the PERM process. So let me go back to the slides. So here are the 3 steps: the PERM process, and then I-140, I-485. So work authorization comes halfway of I-485 application. So first PERM approved, then I-140 approved, then we apply for I-485, and after application of I-485, it takes another 4 or 5 months to get the work authorization approved. Then you get the work permit.
If Miss Y is also an international student but does not find a job, the question is not complete. I'm sorry. Nettie, would you like to type again? Or if there is anybody else that wants to ask, yeah.
So, sorry, this was related to the earlier question. At what point in time the process the spouse can enter? So I mentioned that if the spouse is living outside of the United States, she cannot enter. But what if she, let's say, both are international students, but only one gets a job? Can the other one stay in the US, or does she have to leave?
So let me answer your question. And if I don't answer clearly, you can always ask me again. So this is the entire process. And the first step, PERM, second step, I-140, will not grant you any status, neither you nor your wife or children. So in this entire process of PERM and I-140, you have to maintain your own status, either via student visa or H-1B or visit visa or some other way. So let's say you are in F1 visa and your spouse is in F2 visa and your children are in also F2 visa. So you have, all of you must maintain your status until you apply for I-485. So let's say you graduated and you applied for OPT, you are in OPT, you get a job and all this process are going on, and your spouse is still F1 student or F2 student, she can stay here. PERM will not kick her out, but PERM will not give her anything either. So PERM and I-140 will neither help you nor harm you in terms of staying in America.
Okay, yeah, that answered my question. Thank you so much.
No problem.
Okay, so we don't have any more questions in the chat. If anybody wants to ask any question in person.
I have a question. Do you suggest, as an international student, do you suggest, I guess, asking an employer for the H-1B visa sponsorship rather than going straight for the green card? Like, what is your suggestion in that regard? Because I know, like, once you graduate, you have to apply for OPT and then hoping, you know, for, I guess, a permanent position within the company. So what is your suggestion in that regard?
So that depends on the situation. If you have a good relation with your boss and HR, you can directly say, hey, I'm an international student, I'm in OPT, so I need a green card. So would you please apply for both H-1B and green card, or just green card? But if you feel like, no, I don't have that much good relationship with my boss and other things, so let me wait a few months, work really hard, impress them. When they say, hey, you're doing great job, thank you so much, we appreciate it, then you say, hey, would you please apply for green card for me? So it depends on the situation. But if everything is good, I would ask you to talk with them in the very beginning, because the early you do this, the good for you.
And one more question with the, you mentioned about funds, like to speed up the process, that comes from the applicant itself and not the company. Like, so, it was like $3,200 or something like that. Okay,
so it's a very good question. So officially, applicant cannot pay for anything, especially in PERM process and I-140 process. Applicant cannot pay for the fee. The company must pay. However, in many cases, actually the applicant pays, especially if it is a small company, startup company, they don't have extra money to pay for employees. So they'll say, it's okay, you just go ahead pay. So we, the lawyers, we kind of show that in a way that yes, the company paid, but actually the applicant paid. But officially, it is the company who must pay application fee, not the applicant.
Awesome, thank you so much. Oh, very last question, I'm so sorry. If there's any, like, can we use you as a reference, maybe to contact for future reference, like if employers may need a little more clarity or clarification on the situation? Okay, awesome.
Yes, always. So what you can do is, hey, I attended a webinar by a lawyer, attorney, he said this. So if you have any question, we can set up a meeting. So the meeting can be you, me, and your employer. But if the employer said, no, I want to talk with him in person, like in person means just he or me, not you, then you can ask him to take an appointment from me, and most of the time appointment is free. They can discuss anything and I will explain everything to them.
Awesome, thank you so much.
No problem.
We got a couple more questions here. So does switching companies before a stage 3 restart the entire process?
It's a good question. It depends on the situation. So a lot of time, let's say your I-140 is approved and you want to move, you just applied for I-485 and you just you want to move to another company. If your previous company where you're moving from, if they want to revoke the I-140 or the labor certification, then you may need to start the entire process depending on situation. But if they want to keep it, then you can move to new company. So it depends on your relationship with the company. That's why we always recommend to have a very good relationship with your HR and your boss, that even if you move from one company to another company, they will not revoke your labor certificate and I-140. So it depends on the situation. If they want to cancel it, they can cancel it.
I was under OPT and it already expired. However, the company I was working with started the green card process directly. They are in the step 1. They are advertising the position now. After that 60 days, they will go back to labor right. From there, how long should the process take?
So what is the current status? Did they apply for labor certificate?
Jessica, are you available? Could you ask the question, please?
Yes. Can you hear me?
Yes.
Yes. I mean, I was under OPT, then my OPT expired, but the company I was working with, they started the process.
Mm-hmm.
And we are in the process right now. We are required to advertise the position.
Mm-hmm.
So after that, I think, please correct me if I am wrong, the lawyer needs to go back to labor, right?
Mm-hmm.
And then after that, if that is approved, then that will go to use this with the I-140, right?
Yes.
And then if this is approved, then I can start working.
Well, so right now you're not working, right?
Sorry?
Right now, are you working with that company?
No, because my OPT already expired.
Your OPT expired. So what is your current status at this moment? What visa you are in?
My start F1, and I am taking a certificate. So okay. I am not sure if I am eligible for OPT under a certificate program.
Yes, I totally understand. Yeah, probably you are not. It depends on the program. Probably you're not. So my understanding is that you are in this stage right now. Your company already advertised. They have probably recruited you, and they applied for labor certification. What country you're from, ma'am?
Honduras.
Honduras. I'm not 100% sure about Honduras, but I think you can apply for both I-140 and I-485 together. And
okay.
If you apply for both I-140 and after approval your labor certification, if you apply I-140 and I-485 together, you also apply for work authorization. It's called I-765, and it takes another 4 or 5 months to get the work authorization approved. Then you can start working.
Okay, got it. Thank you.
No problem.
I've heard it is illegal to negotiate with the employer the costs. Having a deal such, I pay for the fees, or you can take from my paycheck or something.
Well, officially illegal, yes. But let's say that's why if you have a good relationship with your HR, and you can definitely talk this kind of thing, it's okay, because nobody is like writing down, hey, we will pay for your PERM and you will pay us in exchange. Nobody will put it down in the employment contract. But let's say you have a very bad relationship with your HR, and if you tell that, they can report against you. It would be immigration fraud. So first, make sure you have a good relationship with them, then you talk this kind of thing.
So I think you answered this question in your presentation, but how long does it take to get the I-485 process?
Right now, it takes from 6 months to 1 year, kind of. It depends on many things, but in general, like 6 months to 1 year.
All right. We don't have any more questions in the chat. If anybody else wants to ask any question, okay, I got any question. If my OPT expires, can you still work if the company applies for H-1B?
Sorry, I was absent-minded. Can you please ask me the question again?
If my OPT expires, can you still work if the company applies for H-1B?
Not just applies. After your H-1B, after your OPT is expired, you must be in a approved H-1B or a day one CPT or any other kind of work authorization to keep working. just because your company applied for you for H1B, sometimes they can keep going. It depends on the situation, but in general, just because your company applied for H1B doesn't automatically qualify you to keep working.
We ran, okay. What is day one CPT, or whatever the term used? I couldn't catch it.
So again, we'll not discuss details about day one CPT here. Please Google it. Also in YouTube, there's a lot of video about day one CPT. In short, when people's OPT is expired and they have neither H1B approved nor any kind of green card, in that case, they can get admission to a university, enroll in some day one CPT program, and under that program, you can keep working full time in a company, and you just have to do some homework and take one exam every semester. Kind of, you don't have to go to school that much. I think 1 or 2 a semester. It's very like, it's kind of like a work authorization with some kind of involvement with the program. But for details, please, we can have another webinar on day one CPT, because it requires a lot of discussion, but also there's a lot of videos in YouTube, and also you can Google it. There's a lot of information there.
Okay. How long do you have to get a job after OPT has been approved?
So after OPT, OPT has a starting date. So you must have a job within, I think 60 days of that date. So if 60 days is expired, then you are out of state. I mean, you are in a grace period. You must leave the country, I think within 10 days or something. So yeah, you must have a job within 60 days of your OPT starting.
We have about 8 minutes. If anybody else have any questions, please ask.
Hi, I actually have a question regarding this. Let's say I have a job, but I haven't started working because my company is given lately. So does it affect like unemployment days? Does it get deducted from the 60 days period, or how does it work?
So it depends on your company. If they say, hey, you know what, officially you did not start working yet, that's fine. But in paper, we will say that this is your official starting date. Then it will not, like whatever mentioned in the employment contract, what is your official start date, that would trigger. So if the company can say it's okay, you can start working later, but officially we're saying today is your starting date, in that case it will not. You know what I mean?
Yes, I got you. Thank you so much.
No problem.
Is the process the same for kids as it is for the spouse?
Yes. The only difference is for kids, you do not need to, I mean, you cannot apply for work authorization, I-765, but you must apply for travel document, I-131, and other things are pretty same.
Next question, if anybody has any question. Okay. A PhD in engineering STEM student with 7 journal papers, 4 conference papers, 53 citations, 27 peer-reviewed judging work of others, country origin not in the cap per country. Majorca, Biden immigration official, announced recently new changes for STEM PhD students last week. In this situation, is it easier to go to NIW instead of asking PERM?
Yeah, I think your publication citation number is good. So I would say yes, it would be easy. And frankly speaking, you can do both parallelly. Like you can do NIW application and PERM process parallelly, and whoever get approved first, you can withdraw the other one. So I would say, yeah, why not?
Anybody else? If not, I'll go ahead and ask a question. See, for example, I'm almost finishing my graduate, degree. So should I apply for NIW or should I wait a little and apply for PERM?
So as I said, you can do parallel, you can do both together. But whether you should apply for NIW or not, that depends on your stat, in your current situation, like how many publications, how many citations, how many peer review, how many, blah, 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 all the things, it depends. So if you want to know whether you have a good profile for NIW or not, I can do some advertisement here. If you go to our website, it's www.rajulaw.com, RAJULAW.com. In our homepage, if you scroll down a little bit, there's a button, it's called click here for free NIW evaluation. So if you click that button, a Google form will pop up. There's like a 5 or 6 small questions. If you answer all those questions, and if you submit your CV, we will evaluate your profile, and we will tell you whether you have a good profile for NIW or not, what is your strength, what are your weakness, what areas you should improve. So we will give you like a idea whether you should apply for NIW or not. But you can do both NIW and PERM. And NIW, you can do it yourself. You do not need any job and you can make your own decision. But for PERM, you cannot make your decision because you have to ask your boss whether they will do that or not.
If you have 2 parallel applications, as you just mentioned, if you don't get approved, it gets denied, say the NIW, does that affect the other application process?
No. One application's approval or denial will not have any impact on other applications.
All right, I think we have 3 more minutes. If we could get one question. Okay. If I don't get a job in 60 days and we have to leave the country, and then what is the way next?
Well, if you do not get a job, then you can always start another F1, another student visa program. Like you can get admission to another program and keep maintain your F1 status, or you can apply for B1, B2, which is like a travel visa. The good thing of travel visa is it's easy to get, but the bad thing is you will not have any work authorization to work outside, work anywhere actually. So there are many options. It depends on your background, your situation, but and if you do not qualify for any of these, then you must leave America.
Does work permit come before the green card comes?
In PERM process, yes, because I-485 approval requires another, like in general, like 6 to 1 year, but I-765 approval is like a 4 or 5 months. So in most cases, you will get a work authorization before you get the green card.
If I-140 is approved, does that mean that I-285 will also be approved?
In 98% chance, yes. But in some instances, it depends on other factors. But in general, if you have I-140 approved, you can think, yes, you will get I-485 approved too.
Okay, so I guess we are closing getting closer towards the end.
Mm-hmm.
We could take maybe 1 or 2 more questions if anybody has anything to ask. All right, so if nobody has any other, I have a personal question. Can I contact you?
Yes, so anybody can contact me in person, like, personally. If you go to our website, as I said, www.rajulaw.com, we have appointments, paid appointments and free appointments. Usually it's easy to get paid appointments, harder to get free appointments because all the time people take it. But yes, we have both paid and unpaid appointments. You can take it and you can discuss 30 minutes with me about any subject related to immigration.
Neri, I don't quite understand the question. Is the green card permanent, that one gets permanent?
Yeah, I'm sorry. So the green card that you get after your I-45 Is that a permanent green card, basically allowing you for only 10 years, or
Yes.
is the
It's a permanent green card. Yeah, it doesn't have any restriction.
Okay, no restrictions and no expiration.
I mean, it expires in 10 years, but after 5 years, you'll be able to apply for citizenship. So you'll be a citizen after 5 years. So you'll not need green card for entire 10 years. But if you do not become citizen for any reason, a lot of people prefer not to be citizen. In that case, after 10 years, you have to apply for renewal. And in most cases, they will approve your renewal.
Okay, thank you so much.
No problem.
Okay, guys, I think we can wrap it up here. It's almost 1:30. Next week, we'll have a similar webinar, and Mr. Mahajan will discuss about application processes if you are applying before you graduate. That is, while you're a student, you can apply for NIW EB2, and he's going to talk about that. We had this event on February 25th, but Mr. Mahajan was a little, he had little health issues, and also but anyway, so we are reorganizing this event to February 8th, that is next Tuesday at 12:30 p.m. So if you are interested in that too, please consider joining. Yes, we'll have link for that event. If you go to our CDLL events calendar, you can get registered for it from there. I'll send all of you the link to our next event too. Once again, thank you so much, Mr. Mahajan, for allowing us to have you with us and sharing all your experience and everything. And thank you, Dylan, for promoting the event, help us organize this event with the students. And with that, thank you everybody for joining us today, and hope you have a good week.
Thank you, everybody. Have a wonderful day.
Bye.
Bye.